Brian Watkins is Mr. Duncan's defense attorney, and I'm going to ask you, Mr. Watkins, what is the significance of this ruling today, and does this put a damper in terms of the DA's ability to use this law as, quote, a tool to suppress gang violence?
Yes, it does. I mean, they've now been told by two separate judges that their application of this law is incorrect. Like I've been saying all along, the way they're applying this law is not right, and it leads to some injustice. My defendant was incarcerated for 8 months, lost his grandfather while he was incarcerated, fighting these charges. Feels very good today to be exonerated. I'm very glad that we were able to get all the charges against my client dismissed.
You think it was overbroad then, but do you see any utility at all in this law?
I don't, especially not the way the district attorney is applying that law. Now, the district attorney's office may decide to appeal that decision and be told by a third judge, actually an appellate court judge, that their application of the law is incorrect. But no, I see no benefit in trying to charge people that had no knowledge of these crimes, these shootings, and incarcerate them while letting the people that actually did the shootings remain free. I see no benefit of that.
This is a rather complicated case because initially there was a group of 15 defendants, including your client. What happened to the other defendants in this case? Some did plead guilty to the pleas?
Yes, I believe some did plead guilty. They had other charges that they dealt with, and they dealt with it by taking a plea bargain deal. The other defendants were separated from us because of a scheduling and because this is the number of defendants. So those cases were dismissed earlier. Actually, they were dismissed last month. Our hearing was today, and all the charges against my client were dismissed.
A couple more questions. The ACLU and other free speech advocates jumped in and said this was an abrogation of free speech rights. You obviously agree with that.
Absolutely. The ACLU was very supportive of us. I appreciate everything that they've done for us. They joined us. They advocated for us on our behalf and said, yeah, this is a violation of the First Amendment. Brandon Duncan's rap music is just that. It's entertainment. It's free speech, and there's no way that you can prove that his rap lyrics encourage these shootings. The people who do the shootings need to be responsible for the shootings, not the person that talks about shooting or gangster rap or anything like that.
No guilt here then by association. Thank you very much, Brian Watkins, for sharing your perspective. As you heard, a key ruling today in this case of the gang conspiracy charges being brought against 15 defendants, including San Diego rapper Tiny Do. We're live outside San Diego County Superior Court. I'm Sasha Fu, KUSI.